And you'll just take it from the top, Lauren.
You guys are live.
Awesome. I don't see myself in Connect Me, but that's okay. So here I am. My name is Lauren Misek Vargas, and I'm the Executive Director of Education Rights Council. Today, we're here to present to you, myself and our co-founder and managing attorney, Elizabeth Einenberger, regarding special education and juvenile justice and what you need to know. We're going to start briefly with just some introductions and what Education Rights Council does, and then talk to you about how we're going to spend our time today. Education Rights Council is a nonprofit organization here and serves all across Nebraska. And our job is to advocate for educational equity by amplifying the voices of our most vulnerable children by removing the legal barriers that all children have, or that children have, so that they can thrive in the school. As I mentioned, I am the executive director. My background is I was an educator previously. I was a special educator, and then worked in the public defender's office in Douglas County, working as a juvenile defense attorney. And Elizabeth, if you want to introduce yourself real quick.
Sure. I'm Elizabeth Einenberger. I'm the managing attorney of Education Rights Council, and I've been practicing basically education law for over 20 years. And at ERC, what I try to do is both act as general counsel and also oversee the representation of clients. So I'm going to flip to the next screen so that we can talk a little bit about what we're going to cover, because part one is going to be me, and then part two will be Lauren. And what we're going to do today is first, we're going to cover like basic statistics and facts about children in the basically children in special education and children in the system in special education. We're going to look at special ed just itself in terms of what are the issues, what does the picture look like, and then what should happen and what goes wrong. And the what goes wrong part is really important because for you all who are advocating in one way or another on behalf of children or working with children, understanding what should happen and then how it gets messed up will help you hopefully get it back on track, which is our ultimate goal. And then in part two, Lauren, do you want to just go over what you're going to talk about?
So what we're going to do is how this applies then to the juvenile court system. And so essentially, what is the general advocacy in court, whether you're a prosecutor, a defense attorney, a GAL, CASA, kind of what your role is, how that then applies in terms of discovery issues and timing issues. And then we're going to go through the entire process of juvenile law, really focused specifically on delinquencies and status offenses, but the same applies to neglects, and we have some examples of that as well. So what that looks like in terms of adjudication all the way through termination of jurisdiction, and potentially if you have a transfer motion to district court.
So I'm going to start with some statistics and facts, and this is really sort of like what we need to know and why we should care. Because when we're dealing with kids, a lot of times the children that we're dealing with, might not even recognize that they have special education needs. So in Nebraska, we have 50,000 students that receive special education services. That means they're actually verified that they have this need. In addition, we have about another 3,500 students with a disability that receive supports under various areas of the law, Section 504 or ADA, that have disabilities but are not under the IEP plan that IDEA provides. 26,000, so over half of these students live in poverty. And between 70 and 80% of children in the juvenile justice system have educational disabilities, but only 37% are actually receiving the services. So identification is a really critical issue, and it's one of the reasons we're starting out today talking about just what it is, what anyone, whether you're an educator or an advocate, should be knowing and understanding and seeing in the special education system. So a few more stats and facts. One national study has shown that among elementary and middle school students with emotional disabilities, 47.7% have been suspended or expelled. But kids with emotional disabilities in secondary school, that number skyrockets to 72.9%. So you're seeing that children with disabilities are perceived and are treated as children that have behavior and problems and end up in the discipline system. So what happens is those students with an emotional disturbance drop out, and children with a severe emotional disturbance have a 13.3 times greater chance of being arrested in school than students with other disabilities. So the point of this is special education, especially what we call the invisible disabilities, which often are your emotional disabilities and or autism, things that aren't as obvious to the naked eye, end up having a disproportionate negative impact on children. So in Nebraska, the 10 most populous cities, Black and Hispanic students only comprise 24.4% of students, but they represent 35% of referrals to law enforcement. They experience 48.5% of out-of-school suspensions, 52.2% of expulsions, and 67% of all transfers to an alternative school. So we are seeing a disparate impact on the basis of race, and then coupled with a disability, children with disabilities are overrepresented in every category of discipline that we track in the state. So that leads to an overrepresentation of referrals to the juvenile justice system, and it impacts every kid's social, emotional, and academic performance. So having an understanding of what this world looks like that many of us may not be immersed in becomes really important to opening our eyes to ways that disabilities may end up negatively impacting our children in a way that we don't need to have them in the juvenile justice system, or the overlap can provide additional supports if we're aware of special education rights and responsibilities, as well as what's happening in the juvenile system. So obviously education and the juvenile justice system interact frequently, and they intersect. And this is pretty much what I just said. And Lauren is going to talk a little bit more about how actually understanding special ed will help you gain access to services that can substitute for or negate actually detention and potentially incarceration, because our goal always is, if possible, to keep children in school. So there's basically a couple things you need to know about special education. Most people know this, but some people don't. The first thing is that it covers people from birth all the way through age 21. Okay, so when you have a child that's very young, they are able to get supports and services through their school district as soon as they are identified. And their very early identification, they have what's called an individualized family service plan, an IFSP. And those are supports that they work with through the state and school districts to both support the family and the child. At age 3, the child then generally moves into an IEP, which is an individualized education program. And this is all under IDEA. And once they're under the IEP, which is similar to an IFSP, but it's more robust, you now have basically goals, services, accommodations that support the child in their educational environment. As I said, not all children with disabilities may require an IEP under IDEA, but they still can get educational accommodations under Section 504. So let's talk a little bit about what that looks like. Some children have disabilities that are really easy to identify, but many are much harder to recognize. And when we're looking at what a child's attorney and or advocate should look for, you want to think about red flags. So you're thinking about what might indicate that something's been missed, that the reason the child I'm working with is struggling is because of a disability that hasn't been identified. And many of these may seem obvious, but might not really point to a disability if you're not familiar with a multitude of disabilities. The first one is consistently poor grades. Okay, if you are consistently getting poor grades, there may be a specific learning disability, there may be ADHD, there could be ODD. There's something that's distracting and standing in between the child and their learning environment. Delays meeting developmental milestones is also a critical one. And depending on what your role is with the child, you're going to have medical records where you're going to be able to see where that child is in terms of for example, if we're talking about autism, developmental milestones, you can find them on like the 16 by 16 signs or the 16 by 16 gestures, things that children should be doing at certain ages. And if they're not, it's a red flag. Lack of interest in school is also a red flag. Children will distract themselves if it's confusing. If I'm dyslexic, I may find that it's much more fun to entertain myself or think school is boring because I'm really struggling and I don't realize that what's happening to me is not what's happening with everyone. If you are also seeing frequent reports about misbehavior and truancy, that actually is a red flag that you should be saying, has this child been evaluated? What do you do to get an evaluation? If there's a red flag, whoever is the parent for IDEA purposes, which could be, let's say they're awarded the state, DHHS, St. Francis. It could be a guardian ad litem that that is appointed as the educational surrogate. Whoever, or it sometimes can even be the school district. Whoever is the parent for IDEA purposes submits a request for evaluation, and upon receiving the request, the school has to engage in a comprehensive eval within specific timeframes. So you can't say, gee, I would like an eval, and the school district says, no, we're not going to do one. They will do an evaluation to determine if it's appropriate to verify the child for a disability for school and academic purposes. Once the evaluation is completed, there's a meeting to go over what they saw, and the parent participates in the meeting, is allowed to participate on the final decision if a child is eligible. And if the student is eligible, the school will meet and discuss the next step, which is an IEP, an individual education plan that's tailored to meet the child's needs. Now, one of the things that people get mixed up is the difference between a diagnosis, which is a medical diagnosis, and verification. In the education world, there are basically, by federal law, 13 verifications. And if you don't fit in one of these boxes, you may still have need for supports, but you will not be identified under IDEA. So let's talk about those verifications. There's autism, there's blindness, deafness, emotional disturbance. That's where you're going to see your anxiety, depression, ODD, hearing impairments, intellectual disabilities, multiple disabilities, orthopedic, other health impairments. That's where, asthma, epilepsy, leukemia, specific learning disabilities. That might be something like dyslexia or dysgraphia. Speech or language impairments. Those can be both. That can be a physical impairment, for example. Traumatic brain injury. This is something that's really important because when you have TBI, sometimes you exhibit things that appear behavioral, but it's neurological. So it's very important to distinguish between a behavioral disability and like an emotional disturbance and a TBI, because you are going to set different goals and give different supports for something that's neurological. And then visual impairments. So one of the things that we wanted to cover today are, what are your rights and how should it work? You remember that I started off talking about how as soon as a child is born, if there is a disability, we want to refer it. The federal government mandates something called Child Find. And what Child Find basically says is there is an obligation to identify a child, every child. It doesn't matter whether the child is going to attend a public school or a private school, we want to identify children. We want to go through that process I just described of evaluation, which is the multidisciplinary team, MDT, goes through and does a series of evaluations. They will look at your academics, your social emotional, your fine motor skills, gross motor skills, psychological eval. They'll do it all. Then they determine whether it's going to be an individual plan. Part of the plans can include what's called a functional behavior assessment and a behavioral intervention plan. What is important for everyone to understand is these may be behaviors that cannot be prevented. So the goal of a behavior plan is not to make a child stop doing something. The goal is to substitute the behavior that is unacceptable with a behavior that is more acceptable. A good example might be if I am, maybe I'm not nonverbal, and when I get frustrated, I just toss my iPad. Probably not the best thing. So we might go through actual instruction to teach a child how to express their frustration in a manner that is acceptable for all parties. Once a child is verified, there's a process that you go through where you develop baselines of where is the child's performance, how is the disability interfering in the child's academic ability to access academics, what goals do we want to put in place so that the child can make progress to closing the gap between the child and his or her non-disabled peers, and then how are we going to measure whether we are actually making progress on that. And we do this every year. The last thing I would point out that's really important is services under special education have to be provided in the least restrictive environment. Now, why is this all important in the juvenile context? Lauren's going to go into this more, but what's very important is to understand this applies IDEA, special education, all these rights apply regardless of the setting in which the child is receiving educational services. So if I'm in juvenile detention, I still have a right to educational services, supports, and IEP, all of that. Some of the things that I think people don't understand that are available is you can get occupational therapy, physical therapy, speech language pathology. If you have difficulty getting yourself from place to place, you have a right to transportation. You have a right to supplemental aids and services that will help you. Assistive technology, which is pretty much any piece of equipment used to help keep the skills of a child or communicate. It's not always fancy tech, but it runs the gamut of whatever you need. There are some magic words in IDEA, things like prior written notice. Prior written notice is something that happens when either under IEP, the school proposes a change in services or the family asks for a change in service. Whether it's the school or the family, they decide whether they're going to do that service or not. And then they give you what's called prior written notice to say, yes, we want to change this up and we're letting you know, or no, we considered changing it up and we're not. Prior written notice is a trigger to let people know that their due process rights may apply at this time because they asked for something and didn't get it. One of the other things that's important is manifestation determinations. So if you have a child with a disability that is being disciplined, after 10 days of discipline, it is mandatory that the school district ensure that it isn't the disability and the manifestation of the disability that is resulting in the discipline. In other words, if it is my disability, I always use this is a really bad and obvious example, but I'm just going to use it because it's easy to understand. If I have Tourette syndrome and it causes me to blurt out things and I'm interrupting, and maybe I'm even interrupting using inappropriate language. If I didn't have Tourette syndrome, I might be disciplined for that. But if it is a manifestation of my disability, I ought not be. We should not discipline students for their disabilities. You also have services like extended school year. That happens throughout the school year. It isn't something that only exists like over summer. It's not summer school. It's if you are a student that needs to continue to maintain services so that you don't regress and fall back, so that you don't lose the progress you're making, you have a right to continue and have additional education called ESY. Parental engagement is also actually a right. If it's only the school being involved and parents aren't being involved, there is a problem there. And the last thing that's very important to understand, especially in conjunction with the juvenile system, is that there are transition services. So when a child is 16 or older, mandatorily under IDEA, the child has a right to be taught how to transition. So if this child is missing skills like how to work in an employment, how to get a job, knowing how, if I have a disability, to access, say, Mobi to get transportation. If I am deaf, knowing how to get my own interpreter as an adult to help me. Those are transition services that are taught, and they can be taught in conjunction with the types of transitions that are happening in the juvenile system as juveniles are transitioning out of, say, probation and the oversight of the juvenile court. Okay. This is really important. Things go wrong. And these are the things that if you're an advocate, you want to look for on behalf of children. And advocate goes across the gamut. This isn't, I mean, judges want to look for these things too if you're a juvenile judge. CASAs want to look for these things. GALs want to look for these things because it may mean that you need to get education counsel appointed to assist you through this process. So failure to identify a child is a problem. We see that happening where the child is referred as truant, and the reason they're truant is because they can't get the help they need to attend school. Failure to find a child eligible despite the evidence that the child is struggling. Sometimes the school will say this doesn't fit when perhaps it should. It is never appropriate for any institution to say, well, look, we just don't have that here. We know your child needs X, but we don't have that. So what you have is what you get is not an appropriate answer under IDEA. Sometimes you have incomplete MDTs. So remember, I think I said it has to be a comprehensive evaluation. Sometimes the evaluation is narrow. Sometimes the evaluation does not necessarily utilize the type of assessment that might be appropriate. So in other words, if I am nonverbal, that could indicate, depending on what assessment is used, that I have a very low intellectual functioning, when indeed that isn't the case. So incomplete or inaccurate MDTs can become problematic. Invisible disabilities are overlooked and not believed. This arises a lot with our very young children. We have children that have not yet been diagnosed with autism, for example, and they look just like every other child, but so people think they're just being naughty. That's a red flag if you have a naughty child that's very young or alleged naughty child. Failure to develop an appropriate IEP. In other words, we have an IEP, but it's not really designed to meet the child's needs. Failure to create a BIP. So in other words, you're asking a child to overcome their disability rather than finding alternate acceptable behaviors. Failure to implement the IEP. You get a great IEP, it's perfect, but people aren't doing what your agreement is. Failure to involve parents in a meaningful way. In other words, the school announces this is what the program is, rather than having a team effort. Failure to give notice of rights. Failures go on, don't they? I think I'm probably boring everyone, and I'm not going to go through all of these, but the point is there's so much that can go wrong. And that's another reason you really want to have a definite understanding of what the rights are and just pursuing that, trying to get to the nub of the issue. The problem is the consequences are so serious. We have 6.7 million children with disabilities in this country. And lack of or late identification has enormous impacts on not only retention, suspension, and academic proficiency, but frankly, longer term, because this starts the child going into the juvenile justice system. when we have students held back inappropriately, they drop out. Nearly 20% of students with verified disabilities drop out. And behavior issues are directly linked to failures in proper identification and failures once they have been identified in getting the services that they actually have a legal right to. So the later a child is identified and receives services, the more likely it is that they're going to end up in the juvenile system. And if they're not served well in juvenile court, to adult recidivism. So understanding when you're in the juvenile court that there are avenues to explore in the school with your child that has special education needs becomes really critical. Here's a real life example, and it's a sort of a tragic one. We had Max. Max was already diagnosed with ADHD and ODD, and he was pre-K in a district where there'd been no child find despite the diagnosis and the identification that should have happened. The family moved to a new district over the summer, and the new district was advised, but decided they would put off the identification and go through the process in the fall, which is also problematic because we need things in place right away. So nothing happened until school started. And by this time, this is a brand new experience for this young boy. And the teacher didn't know what to do. So she put him in seclusion. I am not sure how many people are aware that in every school building in the districts in Nebraska, there are padded rooms where children get locked in. They're called sometimes things like the safety room, but they are a padded cell. And it was terrifying for Max. And his mother was terrified when she figured out what was going on. And the teacher told him that he was going to start his day in that room and have to earn his way out. This is kind of what seclusion looks like in schools. I don't know if people have seen this, but it's not a really good thing. And restraint and seclusion lead to serious injuries and death in schools. Hundreds of thousands of children are restrained or secluded every year. And in November of 2019, a child died being restrained in school. Their specific special education advocacy goes to what is appropriate when you're dealing with educational issues. So when this happens, the first thing you do is try to go through the whole process, right? But there is also due process through the state complaints and due process complaints that involve mediation, resolution offers, hearings, hearing officers. There's mandatory requirement to exhaust your remedies under IDEA before you actually can litigate, but you can also litigate in court under IDEA, ADA, and Section 504. And you can also make complaints to the Office for Civil Rights. So there's a lot of advocacy that can happen in the special education world that is parallel to, but different than the juvenile world. So I think we talked about state complaints, due process, and court appeals. Those are your general remedies. And I thought I'd throw this in just for the attorneys out there. When we're looking at a standard review, we do start at the beginning. So the question of whether a school district provided a free, appropriate public education is reviewed de novo, and the reviewing district has to give due weight to the administrative proceedings. So an appellate court can apply a clearly erroneous standard. So it's just a little bit different than I would call it, regular tort litigation or something like that. I am not seeing that there are any questions at this point. We will, oh yes, I'm sorry, Lauren.
Yeah, so we don't have some questions, but there are just some general questions, or not questions, but concerns. So first of all, a lot of people are asking for the slides for this presentation. As Ms. Ryan had said, it is going to be available via video, but in terms of the slides, we aren't going to be producing them today. However, we do encourage you to go to our website, which is called educationrightscouncil.org. All this information is there in some form or fashion. Please sign up for our emails, or you can email us directly at contact@educationrightscouncil.org. And if you do that, then we will get any of those information. I do think, Elizabeth, you had made a statement, somebody just put in here, that every school has a seclusion room. Gwen Foxall that I see had said that not all schools are that way. So I just wanted to clarify. I don't know if you wanted to clarify your statement, or if just to clarify that school personnel is saying that here currently.
Okay, well, I'd be happy to clarify that from my understanding is when new schools are being built, they are required to make sure that they have these rooms. So and in fact, if we go back to some of the pictures, those are portables that schools have been brought in. I would be thrilled if schools didn't have those rooms. I would be absolutely thrilled. I have yet to be in a school that doesn't have either a permanent or a temporary room like that. If your school does not have that, I think that's wonderful.
And then one other person, I think at one point, Elizabeth, you said maybe we're boring people, but it seems like we're not. So I think that's good. Our really intention here, as we kind of move on to the second part of this, I think that's kind of where we're headed here soon, is to really build an army of advocates, not just attorneys, but school personnel, teachers, community advocates who work with juveniles all across the board, to make sure that you understand and are armed with the information necessary for you to understand even just a little bit of education law, so you can advocate for your kids and for your clients or for the juveniles that you work with. Elizabeth?
Yeah. And I think I need to make really clear that the purpose of this presentation is not to say that schools are doing things wrong. It's that this is a really complicated issue. It's a black box, and educators misunderstand it or are not taught it. Juvenile judges don't understand it or not taught it. Guardians who are working with children don't necessarily understand it. And the what can go wrong part arises because of that lack of understanding. So our real goal in trying to say, look, this is all out there. There are rights and responsibilities that go to all children. And we want to make sure that we're not overlooking them. And unfortunately, the experiences that Lauren and I have from time to time, pretty much all the time, because that's sort of where we are, is we see the where it went wrong part, but we also see very positively that when you involve the education piece, we can get the child out of the system. And I think, Lauren, you're going to talk a little bit about some of the examples that we've seen of where it has been overlooked. And unfortunately, what happens is if the person who is assigned to advocate for the child once they're in the juvenile system doesn't understand that there might have been something that didn't happen at the school, it doesn't happen. So the juvenile justice system is not really set up to also understand the school district's obligations, and yet it is school districts that often are doing the referring of children for, let's say, truancy, for attendance problems. And this is a statewide presentation. We're fully aware of that. But in our larger, more metropolitan areas, and I'll call out Douglas County in particular, my understanding is that we have about 1,500 truancy cases a year coming through the juvenile courts. And many of them, and statistically, 70–80% of those children have some sort of disability that has prevented them from accessing their education. And often when we are appointed, for example, as education counsel and sit down, we do see that the IEP missed something. And it's not necessarily the school district's fault. Maybe nobody told the school district that the child, has been diagnosed. But that gap is what's causing the difficulty for the child being able to access the education. And then the school, has a legal obligation to say, look, if you're not coming to school, we have to refer you. So it's sort of a chicken and egg thing.
I
Lauren,
think
you want me to move
Yeah,
forward?
I think I'm looking, I don't see any other questions. I think that we can kind of move on to the next section as we go forward. We hope to clarify. If you have any questions, keep putting them into the chat, or concerns, or things that we're saying wrong and need clarification. Please feel free to keep doing that as we go forward. I think our next part, Elizabeth, if you'll kind of go to the next part, we're going to do kind of a recap of what Elizabeth said, and then really speak specifically about that integration of juvenile law and education law and how that affects it. And I will say a lot of it is from a GAL defense attorney perspective, but this can be applied also to prosecutors when you're thinking about discretion to file a case or not, or in terms of negotiations, what to ask for from defense attorneys or GALs. And also, as I said previously, it can also be utilized in neglect cases if you are an advocate, whether you're in a school or whether you're foster care or you work for another agency, about what things really should be ordered potentially for the children who are coming out of the neglect. So we'll go forward from there. So a recap, just as Elizabeth said, education rights under IDA, ADA, and 504. So this is the basket of rights that we're really looking at. Right to enrollment, and these are the things that we kind of see happen in juvenile cases or in the juvenile court system. And this may happen, I see some people are from out in, not in Sarpy, Lancaster, or Douglas, where we have specific juvenile courts. This also can be applied to your county courts that handle juvenile issues as well, although that may look a little different in terms of services that are available to you in more Western Nebraska. FAPE from birth to age to 21 for every child. Looking at what types of services, if there was an FBA or a BIP or a BIP, like we talked about, and then that transition program. So this is, again, just kind of a recap of what Elizabeth went over and how this applies. So how does this intersect? And we're going to talk about 3 kind of cases that this happened for that we have worked on specifically. The delinquency capacity, or that specifically, if you're not aware of what a delinquency is clarified as, it's a criminal case that a juvenile or a child from 12 to 19 in Nebraska has committed, and it's referred as a juvenile case essentially for rehabilitation purposes, that the child can be rehabilitated and doesn't need to be a punitive action. That means that if they are found, the incident is found true, they can be placed on probation or kept on court supervision until they're 19 or until they rectify the issue or are rehabilitated. So in Jackie's case, Jackie was a freshman. She was overweight and had left her prior school because of bullying. And she had been diagnosed with depression and anxiety and did not have an IEP or a 504 plan. In this school district, she essentially had started writing a song, or wrote a rap song with explicit suicidal ideations and kind of vulgarities in that song. Somehow the student resource officer, which some of you may have and some of you may not have in your schools, saw the rap and was brought into the involvement in the case and told her, quote unquote, and I apologize for my language, that he was going to cuff her butt or ass and haul her away. And if she did it again, or she did do it again, and she was referred to the hospital the next time because of the suicidal ideations. When she was found not to be a danger to herself or others, she then was placed back into the school. A week later, she did the same thing again and completed the same type of rap song with the vulgarities and suicidal ideations. The SRO extended his, I don't know how SROs function in maybe other counties, but in Douglas County, SROs frequently are participants still with the police department. They aren't school district employees. That's not always true for every school district, but in this case it was. And he went in to search her home, and he essentially found nothing, but he arrested her on terroristic threats. Now, in Douglas County, terroristic threats is what's called a class 4 felony. And all across Nebraska, I guess, by state statute, it's a class 4 felony. And so essentially means that she had threatened somebody's life, or that the person who was threatened felt in fear. She then pled instead to a misdemeanor, but she then was placed at DCYC for 30 days at Boys Town in their PRTF program while she awaited government assessment. Despite the fact that she still had not been hospitalized, there was no IEP, and she still hadn't gotten the services that she needed. Now, as Elizabeth said, it's unclear if child find was done, or I think it's pretty clear here that child find wasn't done because an IEP and a 504 plan weren't created. And there wasn't a determination if this was a manifestation of her disability of depression and anxiety. Our next example is Amelia. Amelia is under a neglect case in which she became a ward of the state, and her parents' rights were terminated for several years. But she had been placed in about 30 foster care systems and had bounced around from school to school to school. In her new school, she had been diagnosed with ADHD and severe anxiety. Now, pre-pandemic, while she was in school, she really struggled to connect with her peers and also to complete work, essentially. She thrived being alone or more in a remote type of homeschooling environment. And so they also did not have an IEP or a 504 plan put in place here. And the services and supports for her were not helpful. In that instance, the court actually appointed education counsel, and we'll kind of talk about that a little later. In Ben's situation, Ben was a 13-year-old Latino boy living with a Spanish-speaking single mother, and he had been referred by his middle school for 2 years of truancy. The defense attorney in this case went to trial, and it was shown at trial that the school never evaluated the child, never did an IEP, and so forth. However, based on how the statute was completed, the court did find that he met the truancy standards of not meeting 20 days within that time. He was adjudicated and placed onto probation. The court ordered him to be evaluated, and he was found to be autistic and struggled verbally significantly, not only because of the second language need, but also just struggled verbally. The school initially, when probation and the court got involved, refused to complete an IEP for him, despite the fact that we now have 2 years of information that he had never received any supports or services, but had only made a referral. So these are just some examples of how the juvenile law system and education issues can overlap in this context. So now that we have an educational issue, just like Ben, Amelia, or Jackie, what do we do? What do we do as a defense attorney? What do we do as a county attorney? What do we do as a judge, an advocate? What are our next steps? So here's kind of just an overview of some general advocacy in court. So although the court can't order school districts to provide special education services, they can request for specific counsel to be appointed just to address that education issue. Now, again, it's a nuanced issue that many attorneys are unaware of how to navigate, which again is why Education Rights Council is trying to build up that army and train attorneys in this specific field and advocates so we can go out and kind of serve that population. But they also can order referrals. Referrals to evaluations to see if a child has a disability that then can be utilized in an IEP meeting by the parent or the GAL or whoever is in charge of the educational rights. They also can advocate for ESY or seek other court orders to have the child be put into that system. I see that somebody kind of asked about educational surrogacy, and I think we're going to discuss what the difference between an educational surrogate and an education counsel is, the difference between those two. I believe that's coming up in our slides. If not, I'll get back to it. The course of a juvenile action, just as an overview. First of all, there's an arraignment for a child who has been filed on, either if that's a status offense, a delinquency, or if a child's being brought in under a neglect case, the arraignment would happen on the parents, but the children would be named in that action. The pretrial negotiations or pretrial, during that time, we'll kind of talk about what you can do there. Adjudication, disposition, where probation services and evals are ordered, and potentially some courts, although it's the Nebraska Supreme Court has continued to say that we can't have continued dispositions. As a practitioner, I know that in juvenile court, we constantly have continued dispositions. So what that can look like. And then also reviews, motions, and then termination of jurisdiction. And we'll go through some other really specific things such as competency and so forth. So at that arraignment or pretrial negotiations, some of the people that may be involved are a judge, a county attorney, a defense attorney, a GAL. You may have CASAs that are involved, and there might be other diversion programs or other advocates in your specific court systems that work here in that arraignment process. Special education issues are based on why a child is removed or referred. So you want to seek what is specifically the basis of the referral, and is the child have a disability that maybe have been manifested based off of that referral. For neglect cases, you want to ensure that if at a protective custody, the children are going to remain out of the home and become wards of the state, that they are getting the appropriate support that they need, whether that's through an ESY or if that is through another type of evaluation. So the first step is to identify the child's educational decision maker, and this is kind of where we're going to get into that educational surrogate. Parents are the first enforcers of special education, but as many people are marking in here, they may not be the appropriate person to be making those decisions, especially in a neglect case where a court may remove the rights of a parent and make the educational surrogate either DHHS or a caseworker, a GAL, a foster parent, a CASA, or another family member. The educational surrogate is specifically designated to make decisions on behalf of the child or who that educational decision maker is. You may request for educational surrogate to be made if the parents aren't following through, for instance, if it's an ed neglect, or if they just aren't following through on getting IEP signed or getting documentation that may be needed. What most parents and counsel don't realize is how far-reaching those protections are when it comes to educational services that need to be provided with special needs. And so sometimes, even though parents are the enforcers of their own special education and have those parental rights, they may not understand how to navigate that. Not only may parents not know how to advocate that, but educational surrogates may also not know how to navigate the really complex issues that occur with special education. And for that purpose, the difference between an educational surrogate and that education counsel is that counsel would be a specific attorney just appointed to rectify the education issue. So it's not, they wouldn't be there for the length of the case. They wouldn't be there necessarily for the best interest. They're just there to represent the child and whoever holds the educational rights to make sure that the education issue is rectified. And then once that is rectified, they would come out of the case. An educational surrogate would be there for the length of the case to ensure the child is enrolled, to ensure that there are if there's discipline issues, that they can handle those things. But for instance, if something comes up and Elizabeth, I see your hand if you wanted to jump in here real quick.
Yeah, I was just going to say the educational surrogate is, I mean, if you simplify it, if you're a parent and you're the parent of the child, you're making all sorts of decisions about the child. Are they going to take French this year? Okay, those kinds of educational decisions. But the educational surrogate does not necessarily have or be expected to have the knowledge to navigate the special ed system. So ed counsel has that very, very specific knowledge, and education counsel will be working with the parent / surrogate to say, okay, this is your rights, this is your responsibilities. You can choose, what do you choose to do given these facts and circumstances?
And I should clarify that not every jurisdiction currently is appointing education counsel. This is something that is new to specific jurisdictions. So I do want to clarify that. But it is something that we, as I said, as we build these armies, are trying to make sure that jurisdictions embrace. So the second step for that individual, if you see that education issue, would be to request the records. Counsel or GAL or the advocate or the educational surrogate can ask for that entire school record, including the transcripts, the disciplinary records, report cards. You'll need a release from the parent or the surrogate to obtain those records. And if there is a purported incident, specifically if there's a delinquency, you may want to ask if they have video of it from the security cameras. Now, in personal experience, video normally is destroyed within 30 to 45 days sometimes in schools. So I would ask for that quickly if you have a delinquency case or something that you felt is arising from that, specifically if you're a defense counsel. If the child has been in several schools over the course of 2 years, like we said with Amelia, she had been in several schools, had jumped around from foster care to foster care home, you may want to be seeing what are those schools and asking for all the records, especially if it's different school districts, if they're jumping from Lancaster to Gage County, for instance, or something of that nature. If there's a record of behavior or health that there is no verification, the district can be requested to engage in that verification process. So specifically, if you're reviewing that case history or the records that you have received, and you see that there's an indication, just like Billy, that maybe the child is struggling because of a disability that either you are aware of or may not know of, you can ask the school if they verified the child, or the school district should be requested to provide an evaluation to the child as well. And that may happen also in a neglect case where maybe evals, you don't want to order the eval, but you want the school to produce that. If there's a determination of eligibility, there should be an MDT that explains that disability and an IEP in place. If not, there needs to be one, and that would be something that we should request for. I see a question real quick. Mary, in your question, you're asking that sometimes parents don't show up for meetings for IEPs, and the schools may give up and need support to make it happen. I guess, and then can the court recommend that a surrogate be put into place? I would say that an education surrogate can be requested, but only if there already is a referral. Elizabeth, would you agree that it needs to be referred on the basis of a truancy or something else, that the school district couldn't just make an action to ask for an education surrogacy? Is that correct?
There's actually statutory strength where the school district can, if parents aren't showing up and the school district needs to go the school district can go and ask, that outside of the juvenile justice system, the school district can go and ask for an educational surrogate and or get named as get the right to proceed to verify, even though the parents are not no shows. So there is an avenue. I'm sorry, I'm struggling for the statute right now. I can get that and get it back to this person. Mary, if you just want to give us an email at contact@erc at educationrightscouncil.org, I will refer you to that specific statute with regard to what a school district can do when we don't have any parents actually trying to show up and it's standing in your way of actually serving a child.
And complying with the law, because we want to make sure that everybody's on board with that too. So thank you. All right, so our third step is, once you've gotten those records, review your discovery list or what you've received, especially if it's a matter that arose from school, if it's a truancy, a status offense, or if it's a a delinquency that came out of the school district. Does the child have a disability? Like we said, have they been verified? That's a question to ask. Does the school record show red flags? Like I said, in Ben's case, where the child was completely missing school, but was also nonverbal, essentially. Was the student verified pursuant to IDA, or was there a 504 plan? Was it put into place when the child was there, or are they just starting to do that? Was the student disciplined by the school, and did they have access to due process? And was there a manifest, if the child has a verified disability or has an IEP, was there a manifestation determination? Was it determined if the child's disability was the reason for the incident? If that didn't happen, you may have a cause of action. And is there a BIP in place or a behavior plan? If not, isn't a creation of a safety plan appropriate that may be required under IDA? And Elizabeth has her hand up. Go for it.
Sorry, if I were listening, I would have a question. And here's my question or
Go.
statement, which is, one of the things that I think is really important here as we're going through this discovery checklist is, if you are a public defender or a guardian and you're going through this checklist and there was a manifestation determination, I want to go to the other side. What if there was? How that can be utilized to show the court that this is a disability issue, and we shouldn't be putting the child through the juvenile system. Maybe this child doesn't belong in the system if the whole reason he's here is because this is a manifestation of a disability.
And I see that somebody else wants that statute number. Again, contact us at ERC, and we will get that information to you. If you email us right now, we can get that to you soon. Next slide.
Oh, sorry.
Sorry. Okay, so what happens at adjudication? So we've had our pretrial, we've had our arraignment, and now we're either going to go to trial, or the child has decided to plead, or to admit that the incident is true. Special education can arise in status and delinquency cases. As we said, it can kind of come up here. You can use all that information in a trial if you decide to go to trial. You can call witnesses. That's what the purpose of that kind of discovery list is. If the child has admitted to the incident, whether it's delinquency or a status offense, specifically a truancy, now you are equipped with the information to ask for it at a disposition. In a neglect case, the same thing is true. If you gather these records and you're a GAL county attorney, and the basis of the neglect essentially is, let's say, an ed neglect, or even more, essentially that the child just being completely ignored by the family. This may give you another avenue, or more evidence if you call a teacher or a school administrator or an IEP coordinator to say, look, the parents aren't coming to the IEP, they don't care about the children's rights. And in Mary's case, if you wanted to get an ed surrogate, it might provide a basis for you to ask for an ed surrogate because the family hasn't done anything, if you review those records. One other thing that we want to talk about is incompetency. There are issues frequently where a child may not be competent to stand trial or to admit to a case if they are below functioning. Now, in a criminal context, that is a really low, it's even lower than determining incompetency as a disability or as a low functioning individual. It's, do they understand what they are accused of? Do they understand who their attorney is? And do they understand the judge, kind of all those roles? But can they help in their defense is really the key question in that competency evaluation. Now, frequently, if you believe a child is incompetent to stand trial or to be placed on probation or any type of rehabilitative services, it may be worthwhile to ask for a competency evaluation. However, it cannot be an IQ test. That is different than a competency evaluation. The competency evaluation needs to be done under kind of that criminal standpoint of asking those questions. Can they actually assist in their defense? Do they know the role of the court? Do they understand what they're accused of? If the evaluation comes back that the child is incompetent, the juvenile child is incompetent, unlike criminal court or district court, where there's other actions that can be done. Frequently in juvenile court, that may mean, because it's not a punitive court here in Nebraska, that there is no longer a case, that the case thus needs to be dismissed because the child then can't be rehabilitated. However, if it comes back that the child is competent but low functioning, so below a 72 IQ, or even kind of sitting at that like 80 mark, right? Then you may have some information to then apply and utilize for either your trial or for your disposition in terms of evaluations you can ask for. I will tell you, as a defense attorney, I've done this several times, and in both instances, specifically, I had a child who we ended up finding out was autistic based off of this evaluation. He was not incompetent for purposes of criminality. However, he was lower functioning and autistic. And so that information then informed what supports and services I asked for in the next stage, which is disposition. So at a disposition, if a child, as we said, has decided to plead to truancy or delinquency, we can ask for certain services. So that includes evaluations, that includes potential placement. It also includes maybe the ed surrogacy component. We also can include maybe some supports. You want a GAL to be appointed to help assist the family to make sure that the child gets an IEP or education counsel. This would be the space to do that in. If you're unable to access those records, as we kind of talked about before, in a timely manner, it might be helpful to get education counsel if you're in a jurisdiction that does that. We kind of talked about the IQ piece. Frequently, sometimes after a PDI is completed in probation, even if a child is not incompetent to be adjudicated, the child may not be eligible for probation because they can't offer the supports and accommodations that are necessary. So the jurisdiction may be terminated just off of that basis as well. At disposition, you are trying to gather and get the services that may include where or what can aid that child to be rehabilitated as fast as possible, if they can be rehabilitated, to make sure that their disability is taken into account in that aspect. It also can be used if a child is low functioning or has a severe disability. Isolating a child, for instance, if you have depression or anxiety in a secure facility, could be extraordinarily harmful to not only them mentally, but also may be in violation of what their disability is, and exacerbate that behavior and could cause more issues. I also recognize that in Western Nebraska and in some other places, there may not be all these services, all these evaluations that are possible. So you also can potentially, as I said, rely, and although the court can't order the school district to do certain things, you as the GAL can request that the parent go in and ask for an evaluation for an IEP, and try to navigate what the school's offerings can be to hopefully maybe get a collective picture on what the child is going through or what disabilities they have to try to help rehabilitate them. We kind of talked about probation here just briefly. As I said, with probation, if they have that special education or accommodations, what accommodations can probation provide? Some examples of what accommodations may be needed, for instance, I had lots of clients who really struggled to take verbal commands or verbal actions. They really needed everything written down. So I requested that my probation officers make sure that they wrote down step by step what the client had to do, because otherwise, if they would forget what was happening. That's just kind of a differentiated approach that can be utilized and should be utilized by probation officers, but should be requested on the behalf of the child by the counsel or GAL. The probation also needs to understand what the child's disability is. If you have a child with an emotional disturbance, as Elizabeth was talking about, or ODD, and then they're wondering why when confronted, the child says F off, well, that would then be a manifestation potentially of their disability. They also may not understand a child who potentially is on the spectrum and doesn't look them in the eye and doesn't have the same kind of social cues that others may have. So understanding that not every child or every juvenile is created equally, and that a probation contract needs to be differentiated not only for what the case is adjudicated on, but also for the child is extraordinarily important. You can also use probation to help kind of work with the school system to trying to get all of those other services in place. Frequently, probation will help parents also navigate that. And so they can kind of just be an insight into what's going on at school. Oftentimes, probation officers have more access to the school than potentially counselor or GALs do. So they also can be helpful for that purpose. Now, after disposition services are provided, essentially you're going to have periodic reviews. You want to make sure that their educational issues, especially if they have a status offense or a truancy, are being addressed, and that additional services can be ordered. Now, if a child is revoked because they aren't, or if there's a motion to revoke, which specifically would be because they aren't complying with probation. But if the basis of the violation is, for instance, they're still not attending school, this may be a really huge red flag to you is, okay, the child came in, for instance, for a marijuana possession. The child now, went to treatment and isn't smoking marijuana, has not tested positive for drug testing, but isn't attending school. So that's the only reason they aren't getting off probation. Well, this is a huge red flag then to counsel, to the county attorney, to the GAL, that in order to make sure that the child is fully rehabilitated, quote unquote, or even to the judge, to recognize that maybe education counsel, education surrogacy, or we need to kind of dive into what those records are to see why the child isn't being successful. In a neglect case, as many of you who maybe be participating in those know, services can be ordered at any time. So at any review, if there's a red flag or an education issue comes up, you can always request the judge order those services. In a delinquency or status offense, that can only be done at disposition, or if a motion to revoke has been filed on the child. Now, one thing specifically I want to talk about is transfer motions. If a child has, let's say, committed a very, very serious crime and now are being tried as an adult, either in county or felony courts, and this is really specifically for delinquencies. Status offenses cannot be transferred because they are not criminal actions. They don't apply to adults. But if you have a child with a gun case, for instance, or as we talked about, the terroristic threats, and they are transferred to district court, there is an action that a defense counsel can do, which is called a motion to transfer it back to juvenile court, and or the opposite, a county attorney can transfer it from juvenile court to district court. In either case, the county attorney or the defense counsel in those sectors want to look at what documentation and IEPs support their position. If you have a child, specifically in defense counsel, who has a significant disability that hasn't been addressed by the school, and they brought a gun to school and now they're being charged in district court, you may have a cause of action to talk about, well, they never had the IEP, they never had a 504 plan. But your goal then is to try to explain this really nuanced law to the judge and why it now applies to the rehabilitation of this child and why this child should then receive a second chance in juvenile court. The flip side would be the opposite for a county attorney or somebody who's trying to transfer it out of juvenile court to county court, essentially showing, look, the school's done everything and juvenile court has done everything for this child. They shouldn't receive a second crack at the whip, for instance, and should be placed into district court at that time. And then at termination of jurisdiction, so at this point, a case would completely end. So a child who either appears to be ungovernable or maybe incapable or absent of really picking up those, getting the appropriate accommodations, you might be able to present that to the court and say that jurisdiction should be terminated. And really the distinction is it terminated successfully or is it unsuccessfully? The reason why that matters is if a case is terminated unsuccessfully, it remains on the child or the juvenile's record. And so anytime they commit a crime or they go apply for a job or they apply for military, which is specifically a concern frequently for many of my clients, is it may stop them from being able to get that job or get into the military. In fact, to get into the military, you often have to have a certified letter from the court that the case was completely dismissed successfully from the judge. So these things may help you make specific arguments to making sure that, look, yes, the child still wasn't attending school, as I talked about before, but we rectified the issue that brought the child in here in the first place. For instance, the marijuana possession case. Also, some courts have dismissed some status offenses and related minor delinquencies because the schools failed to implement the appropriate educational program for the child. And seeing that it wasn't because it arose from school, maybe they aren't providing those supports and they want to give the child another chance in the school district. So kind of in conclusion, as we kind of wrap up here and try to get some more questions, special education concerns can exacerbate or complicate whatever behaviors brought a child into contact with the juvenile court system. Counsel, whether that's GAL, whether that is defense counsel, if it also is the county attorney or another advocate, you are able to take an active role in advocating for better services for your client. And it can really impact what the course of your case is, as what the course of your delinquency, status offense, or even neglect can happen. Also, there's several actions that could potentially happen at the same time. I'm actually going to have Elizabeth kind of talk about this, an example of if you had due process or if you had a juvenile court case together.
Yeah, I think that, thanks, Lauren. The one thing that we really wanted to make people aware of, and it seems sort of obvious, but not necessarily, is that if you have multiple things happening at the same time, you could have a due process with regard to a discipline happening at the school completely independently from what's happening in the juvenile court. At the same time, you could be having a special education issue that hasn't been addressed. And so you could find yourself in a hearing before the school board because of the student's discipline, a hearing before the state on making sure that the school district actually provided FAPE to the student, and in your juvenile action, working on the rehabilitation of the juvenile within the juvenile court structure, whether it's delinquency, neglect, etc. So when that's happening, understanding, I'll call it those shifting tides, and regardless of who you are, making sure that you aren't making a record in one place that doesn't fit in another place. Be very careful about fully understanding what the rights are, the obligations are. So in the discipline, you're understanding the manifestation piece. In the special ed construct, you're understanding that if there was a failure to provide services, what remedies are available to you and how those fit together to bring to the court and say, look, court, this is what we're doing here, and pulling it together so that the court can also see that there are avenues for rehabilitation that should either be reported upon, explored, or incorporated into what the court itself is, the juvenile judge is doing, her or himself. I think that's what we wanted to do there. Do we want to see if there are any additional, I don't know if we have another slide. Let's see. Yes, we have resources.
Yep, here's some resources kind of for you. I'm looking to see if we have any questions. We have about 10 minutes left. If people have direct questions that they want to ask.
We'll give it a couple minutes. I will say that we're doing sort of a double system here because we are utilizing Zoom and the questions are going through ConnectMe. So we can also have a little bit of a delay between a question going in and a question showing up on our screen. So if that's happening, we apologize for the technological challenges we all face these days.
I don't see any questions on here, but I just really want to encourage you again to please reach out to us. We want to be a resource for you no matter what advocacy role that you hold, whether that's as an attorney, administrator, teacher, community advocate. We hope that this session has been informational for you and was helpful for you. If you have more specific questions to your exact role, we are constantly doing educations like this for the community, the broader community, and also for parents and families as well. So you can either sign up to our website or tell us what you would like. We partner with organizations frequently to do more specific training to ensure that you understand how these rights apply to really what your role and your context is. We've done that across the state, and especially now that Zoom is so readily available, are willing to do that. So we really hope that you meet with us and contact us. We truly appreciate your time and your questions. And thank you so much for getting to know a little bit more about not only education law, but Education Rights Council. Thank you so much for this afternoon and taking the time to be here.
I think that concludes our meeting, so we'll leave. Have a nice afternoon, everyone.
Bye.